And the man of that moment, who has played through his party as well, an instrumental in a role in getting us here, is with us this morning. Vuyolwethu Zungula, thank you for joining me. I know it's freezing, but I guess you would weather any storm to be here at the Constitutional Court. What does this moment mean for you?
For us, I think it is a matter of life and death for our democracy, because the democratic project which we started in 1994 rests on the ability of the institutions to play their role, because we live in a constitutional democracy. In a constitutional democracy, the Constitution reigns supreme, and because the Constitution reigns supreme, in the event that the executive or parliament fails in its constitutional obligations, it becomes paramount that the constitutional order, the Constitutional Court must restore order. And today, the ruling today will either really affirm that, firstly, we're all equal before the law, and indeed there is a rule of law in our country, or if it does protect the most powerful office in the land, then I think the ramifications for that is that people would not have confidence in the judiciary. And why would then people follow the law if the law is not equally applied to the most powerful people in our country?
Very, very important. And to my left, actually, over my shoulder, and you can see it, it's in your line of view, is what's called the flame of democracy. It sits here, and it very much exemplifies this principle of equality before the law, no matter what your station in society is. Thank you for that reminder. But let's go back to the moment where you get the Section 89 independent panel to essentially be formed, and the petition that you had made to the then Public Protector, Advocate Busisiwe Mkhwebane. Take us back to those early moments.
When Arthur Fraser went to the public and detailed how laws were basically broken in the Phala Phala scandal, we were reminded as a party that, firstly, we are there to serve the people, and it is our constitutional obligation as a party in Parliament to hold the executive accountable. And part of the mechanisms of holding the executive accountable when it relates to the president is the Section 89 process. We embarked on various mechanisms. We wrote to the Public Protector, IPID, other institutions as well. But the role of Parliament, ultimately, that is where the president accounts. The Constitution does set aside Parliament as an institution where it is legally obligated to hold the president to account. So when we got the report by the independent panel, and I think the distinction about the independent panel is that the independent panel, as the word states, it is independent of the politics, independent on the current governance structures, because it is people who are independent, from being influenced by the ruling class, which is the ANC or the senior leadership. Hence, you find that they issued a report that says there is a sufficient evidence that would warrant an inquiry. And I think that is what people have been missing, that they did not say the president must be impeached. They said there is sufficient evidence to warrant an inquiry. Now, for the ANC in December 2022 to abuse its majority by blocking any form of an inquiry, it goes against Section 42(3) of the Constitution, because that section mandates the National Assembly to scrutinize or have inquiries on the conduct of the president. And the last issue here is that the independent panel comprises of distinguishable individuals, former Chief Justice, and their role is very clear, because they come with an expertise, a legal expertise more than anything, because the Section 89 process, it is more legal than anything else, because it deals with violations of the Constitution. Therefore, once you have legal minds, experienced legal minds, saying there's a case to answer, there would be no reason there for Parliament to second-guess their views of a legal process.
And would have offered, as you say, in a sense, this beautiful opportunity to actually let the Constitution do the work of the Constitution. We will be talking to the ANC's Mahlengi Bengu Shabiri later on in the program to talk about that moment where this whole matter could have potentially been laid to rest. You mentioned Arthur Fraser. He was the former head of state security at the time, who then went, I mean, there were questions about why wait 2 years? You know, why go in 2022 and not in 2020? What are some of the other issues besides the pursuit of this legal principle? And we've got to remind our viewers that the apex court today is not going to decide, as Vuyo has also said, on the guilt of the president. It's really going to focus on the work of those lawmakers and whether they'd failed in their constitutional duty after this panel found, as Vuyo is also reminding us, this prima facie case for a potential impeachment. What are some of the other attributes, Vuyo, that did not sit well with you besides the conduct of Parliament?
Firstly, it is the issue of how Parliament, firstly, in its constitutional obligation, really failed to scrutinize the executive in that the president in the sitting of the Phala issue. The other issue here is that when it comes to the rules of Parliament, Section 129, we have this process of the Section 89 process, if you recall, it came about in December 2017 when there was a Nkandla matter, which was also brought before the Constitutional Court. Back then, the Constitutional Court said there must be a mechanism for the Section 89 process to be fully implemented in Parliament. Now, the process would have been a three-step process. Firstly, there must be a report that is done by an independent panel to ascertain whether there is a case to answer. Then the following step would be an inquiry, which is an impeachment committee. And then the last step would be a vote in Parliament, whereby to determine whether a president is impeached or not. Because prior to that Concord ruling in 2017, there were no rules that would give effect to Section 89 in terms of how a president could be impeached. You'll recall that it was only Section 102 which speaks about the motion of no confidence, which is largely political. Whereas here, a Section 89 process, it is largely legal because it deals with constitutional court violations. So if then...
Constitutional violations.
If then you have an instance whereby Parliament or the National Assembly then would want to second guess what legal minds have said there is a case to answer. That is in the rules, and one of the things that we view that it is something that really weakens the role of the Constitution, because the protection of the Rule 129 is that it needed to insulate or remove the interference of Parliament and their political processes on legal issues.
Well, two things very quickly before we go to break. What are you hoping for today? I mean, it's obvious what you're hoping for, but it's a very different Parliament now.
Yeah.
So if this goes back to Parliament, what do you think is going to happen?
The GNU, they've got a statement of intent. The statement of intent, it is said that it is anchored on the Constitution and the rule of law. So if the Constitutional Court said in 2022 Parliament failed, then it's a straightforward case that the parties, especially the ones in the GNU, must vote right and undo the mess that was done by the 2022 Parliament.
Well, just less than 3 hours or so to go, Vuyo, and we'll see which way the court goes. So much at stake. We'll be live after this break with our reporters in the field, including potentially a live position outside the Phala game farm, where all of this initially began. More after this.